NACDL is the association of the nation's criminal defense bar.
Hello, I'm Norman Reamer, Executive Director of the National Association of Criminal Defense Lawyers, NACDL. For years, NACDL has fought against overcriminalization, the indiscriminate use of the most awesome power of government short of warfare, the power to prosecute. The United States has a long and dismal history of using criminal penalties to control all manner of personal and social behavior that has nothing to do with classic notions of what constitutes a crime, things like theft, assault, and other common criminality. Criminal regulation of disfavored behavior that is not fundamentally criminal leads to mass incarceration and feeds racial and ethnic disparity. And now we see the use of criminal sanctions in a whole new area, the use of criminal penalties to impede access to the ballot. NACDL will leave it to others to debate the wisdom of limiting ballot access. But when criminal sanctions are employed in this area, NACDL will not stand silent. The state of Georgia has enacted a raft of new criminal penalties related to voting. To meet this challenge, NACDL hopes to equip lawyers to vigorously and effectively defend those accused under these overly expansive and irrational criminal provisions. We are pleased to have two terrific lawyers to conduct this program to meet that challenge. Mitchell Brown is an Equal Justice Works Fellow at the Southern Center for Social Justice. Mitchell is a graduate of North Carolina A&T State University, where he earned a BS in Business Economics and a minor in philosophy. And he is also a graduate of New York University School of Law, where he served as chair of the Black Allied Law Students Association. After earning his law degree, Mitchell clerked for the Honorable J. Michelle Childs of the United States District Court for the District of South Carolina and for Chief Judge Carl E. Stewart of the United States Court of Appeals for the Fifth Circuit. Mitchell has devoted his professional career to defending the defenseless and empowering the powerless. Mark Loudon Brown is a staff attorney at the Capital Litigation Unit at the Southern Center for Human Rights. Before that, he was a criminal defense attorney in the criminal practice at the Bronx Defenders, where he served as the forensic practice supervisor, overseeing the forensic practice group. Mark earned his law degree at New York University and thereafter completed 2 years as a Prettyman Fellow at Georgetown Law, during which time he represented indigent individuals accused of crime in DC Superior Court. He also earned his master's in trial advocacy at Georgetown. I'm now pleased to turn the program over to Mitchell Brown.
Thank you, Norm, for the generous introduction. As Norm stated, my name is Mitchell Brown. I'm counsel at the Southern Coalition for Social Justice in Durham, North Carolina, where I'm an Equal Justice Works Fellow sponsored by the Ottinger Foundation. I want to say thank you to Norm and NACDL for having me here today, and I'm grateful to be one of my colleagues, Mark Loudon Brown from the Southern Center for Human Rights. So thank you, Mark, for joining us as well. And today we just want to have a conversation about Georgia Senate Bill 202 and how it could lead to voter prosecutions for voting, as well as for voting adjacent activities. And before we start, I just want to give a couple of background things to think about as we enter into this conversation. To set the foundation for today's conversation is first, Georgia's history of voter suppression is so robust that courts have taken judicial notice of this history. If you look throughout the case law, you'll see that Georgia's history is long and it's been rampant voter suppression since the end of the Civil War, as Georgia has aimed to suppress the Black vote from, again, after the Civil War and to present day with Senate Bill 202. Second, is Senate Bill 202 comes after increased voter participation in the 2020 presidential and senatorial elections. As many of you may know, former President Trump filed many cases challenging the results of Georgia's election, saying that there was voter fraud in the election, and that ended up not being true, and those cases were dismissed. But also in this 2020 election, both the presidential election and the senatorial election, there was such an amazing amount of voter turnout, historic voter turnout in Georgia, that really set the foundation for SB 202 to be put into motion. Because of this increased voter turnout, Georgia, the legislature said, hey, we got to do something about this. And that's why they passed SB 202, or that's what the cases argue that why they passed 202. And lastly, SB 202 could lead to widespread prosecution for non-fraudulent conduct, such as handing food and water to voters in line, putting another voter's absentee ballot in the mail, or even going into the voting booth to help a voter. Like, all of these issues are not non-fraudulent conduct. They are simply people trying to assist other voters or trying to encourage them to stay in line. And under the statute, those types of conduct can be criminalized, and that's an issue. So just to give everyone a short history of voter suppression in Georgia, it's a very short history. According to one of the many complaints filed against SB 202, it was recorded that from 1965 to 2012, when Georgia was under the pre-clearance provisions of the Voting Rights Act of 1965, Georgia's racially discriminatory practices required federal intervention 187 times. For those who are not familiar with the pre-clearance provisions of the Voting Rights Act of 1965, which were housed in Section 5 of the Voting Rights Act, pre-clearance meant that if your state was covered under pre-clearance, you had to get, before you passed any voting laws, you had to get permission from the United States Department of Justice or from a 3-judge panel of the DC District Court in Washington, DC. And the standard that DOJ and or the court would use was the law that was about to be passed by the state going to hinder Black voting rights in the state. They called it retrogression. And there had to be no retrogression in the status of Black voters in the state in order for the state to pass pre-clearance. So when Georgia, from 1965 to 2012, Georgia, the federal government had to intervene 187 times. Now, as many may know, Section 5 of the Voting Rights Act and the pre-clearance provision was struck down. The formula for the pre-clearance provision was struck down in 2013 in a case called Shelby County v. Holder. And so once that was struck down, states and municipalities that were under pre-clearance were no longer under pre-clearance anymore. And to be clear, it was a formula that the Supreme Court said was unconstitutional, not pre-clearance itself. Pre-clearance itself is very, very much constitutional. But federal government had intervened 187 times in Georgia. In other states previously covered by pre-clearance, Georgia is the only state since the Shelby County decision that has enacted voting restrictions across 5 major categories studied by the United States Commission on Civil Rights: voter ID, proof of citizenship, voter purges, cuts to early voting, and polling place closures or relocations. What this means is that in those 5 categories, Georgia has passed and enacted statutes that limit voting in these 5 categories, or suppress the vote in these 5 categories. And to date, no Black man or woman has ever been elected governor of Georgia. And Senator Raphael Warnock in last year's election in 2020 has been the only Black man ever elected in the state of Georgia. So turning to Senate Bill 202, as I stated in my opening remarks, there are many what I'll call criminalization components of SB 202 that are going to criminalize non-fraudulent conduct. If fixing voter fraud and prosecuting voter fraud is the aim of SB 202, this is not going to do it. These criminalization components are going to criminalize harmless, innocent conduct that is not aimed at capturing or prosecuting or changing voter fraud. The first of many criminalization components is handling a completed absentee ballot application if you are not the voter or an authorized assistant. So that's a misdemeanor. according to the statute. And what this means is that if you are not an authorized assistant or you're not the voter yourself, you cannot request an absentee ballot on behalf of somebody. And if you do, that's a misdemeanor. Second criminalization component is opening a sealed absentee ballot envelope if you're not the voter or an authorized person. That's self-explanatory. And just to note, authorized person means that you are assisting somebody who is illiterate or does not speak, they don't have a ballot in their native language. So that's what I mean by authorized person. Another criminalization component is allowing a person to see an absentee ballot being marked, even if it's at home, and having done so voluntarily subject to certain exceptions. So the certain exceptions are if you are an assistant, so you're assisting the voter, then you can see them mark the ballot. But according to the statute, you have to swear an oath at the end of your absentee ballot saying that nobody saw how you marked your ballot. And if somebody saw how you marked your ballot, then you cannot swear to this oath because it creates a felony if somebody saw how you marked your ballot. Not that you're trying to commit fraud, and not that that other person is trying to sway you one way or the other. If they simply see your ballot, then it's a felony for false swearing, or can be a felony for false swearing. Now the prosecution has to prove its case, but this could open the door to meaningless felony prosecutions for somebody simply viewing a ballot in the absentee ballot context. The next component is giving water or food to a voter waiting in line, and this is known as line warming. So this may be the part of SB 202 that you've heard the most about in the media, and in the one that's been talked about the most, because what this part of the statute says is that you cannot give food or water to people standing in line. You cannot approach somebody you cannot become within 25 feet of a person in line. And you have to, if you're going to hand out stuff, you have to be outside of 150-foot radius from any voting place. And so what this looks like is people standing in line, and what happened in the past is that local churches, the local NAACP, and other voter engagement organizations would hand food and water to people in line and encourage them to stay in line and encourage them to let their voice be heard. However, SB 202 criminalizes this conduct and says that you can no longer do it. And I'll talk a little bit later about this, but one of the major claims against this particular part of the statute is that it limits the free speech of the voter engagement organizations, because this is part of their mission, encouraging voters, turning out voters to the polls and engaging voters. They can't do that now because line warming is now a misdemeanor under SB 202. Other criminalization components are intentionally observing another person casting a ballot unless the observer is a child or providing authorized assistance. So we talked in the previous slide about somebody viewing an absentee ballot and the voter having to swear that nobody saw how they voted on their absentee ballot. This is in the in-person context. This is in the polling enclosure, in the polling place. Married couples can't even go into the polling place, the polling enclosure anymore to vote together, because if a married couple or partners, they go into the voting booth and they both have a ballot and they both vote that ballot in view of the other, they both can be found guilty of intentionally observing another person casting their ballot, and that is a felony under SB 202. So I'm from North Carolina, and historically I've seen people go into polling place together because that's just what they've done their whole entire lives. Under Georgia statute SB 202, that no longer can happen. Two other criminalization components are photographing a voted ballot. So you may have seen on social media, people will take a picture of their ballot and say, "Hey, I voted, you should go vote too." Under SB 202, that's a misdemeanor, and you can no longer do that. And the last criminalization component is mailing or delivering to the board of registrars a person's absentee ballot if the person is not a family member, a member of the household, or other authorized person. So this really applies to third-party organizations that would help people, put their ballot in the mail, put their absentee ballot in the mail, or take it to the registrar's office, or even a neighbor. If you have a neighbor and you ask a neighbor to take this to the mailbox, because that person is not in your household and is not an authorized assistant, that person can be charged with a felony if they possess your ballot and try to put it in the mailbox. And so that type of conduct, again, not fraudulent conduct. The person is not trying to steal other people's ballot. They're simply trying to put it in the mailbox to help, and they can be criminalized for that. Some examples of how the criminalization elements that I just mentioned are being challenged. As I mentioned about line warming. So in the 6th District African Methodist Episcopal Church versus Kemp, they brought a free speech claim saying that the ban on line warming activities prohibits their expressive conduct and criminalizes it. And I talked a little bit about this before, but what would happen in the 6th District is local church members would go to the polling places and encourage people to stay in line and encourage them to let their voices be heard because it was so important. And Georgia has a history of having long lines, and these long lines have discouraged many people. You may have seen reports that lines in Georgia, people are standing in line for 4 or 5 hours just to cast their ballot. And what we've seen through data is that these long lines are in Black and brown communities in Georgia. And so the 6th District, as an African-American church, would go and encourage people in their community to stay in line and to register to vote. And because SB 202 criminalizes it, they no longer can do that. And they claim and allege that it impinges on their First Amendment rights to free speech because this is the type of conduct that should be protected. Another criminalization element that's being challenged in particular is the observation felony provision that I mentioned about somebody viewing how somebody else is voting. And they doing this under voter intimidation because people in the polling place and poll observers and poll workers could say that somebody is observing another person and how they are voting, and they could be charged with a felony. And that's a problem. And so this felony observation provision is so broad that it could possibly criminalize people for just like passing by a window and seeing how somebody is voting without even trying to see how they're voting, not intentional. And so this part of the statute does have an intentionality, component to it, but it is possible, what is intent? And so that's something that this part of the statute is really broad. And so the Coalition for Good Governance brought a voter intimidation claim against SB 202, challenging the elector observation felony provision. And one thing I want to note is, again, if the purpose of SB 202 is to prevent voter fraud and to prosecute instances of voter fraud, none of this has to do with voter fraud. This is merely trying to suppress people's right to vote and trying to decrease turnout and depress turnout because of the chilling effects that will occur with SB 202. So the question that we ask is, why does protecting voters and voter engagement organizations from criminalization matter? Like, why are we here? And a couple of reasons why we're here and why we wanted to do this webinar and think it's important that we protect Georgians who may be prosecuted under this statute. The first is that there's already been a high-profile voter prosecution that occurred in Georgia in the case of Olivia Pearson, who my colleague Mark will talk about in a minute. Second is criminalizing voting or voting adjacent activities is happening in other states. This is not a Georgia-specific event. In years past, Tennessee tried to make it a misdemeanor for voter engagement organizations if they missed deadlines to turn in voter registration forms or they failed to complete state training on voter registration. Now, a court struck down this statute in 2019, but Tennessee tried to criminalize voter registration. They tried to criminalize the organizations who were turning out Black voters in Tennessee. The state tried to criminalize that, saying that if you turn in a certain number of incomplete voter registration forms, or you don't do the state mandated training, you can be charged with a misdemeanor. So they're criminalizing voter registration activities. In Texas last year, because of the COVID-19 pandemic, many county boards of elections in Texas were trying to send absentee ballot request forms to all Texas voters, regardless of whether they requested one. And this was in an attempt to kind of ease the process. We were in the middle of a pandemic. People weren't sure if the United States Postal Service was going to work, and if they sent out their absentee ballot request form, if they're going to get their absentee ballot in return in enough time to cast it. And so some county boards had the idea, like, let's send it to everybody to kind of ease that process. Well, the Texas legislature took umbrage to that and tried to pass a statute that would criminalize the sending of absentee ballot request forms to all Texas voters. Again, has nothing to do with voter fraud and everything to do with suppressing the right to vote. And they also tried to criminalize innocent mistakes regarding proper voter assistance and tried to make it a felony to pay people to assist voters. To that last part, many organizations would pay volunteers to assist voters. So the elderly, those who have disabilities, those who their native language is not English, they would try to pay they would pay volunteers to help, pay people to help assist those voters. Texas tried to criminalize that. And then lastly, in Arkansas this year, passed a similar line warming bill to SB 202. And so what we look at these three states in particular, or four, including Georgia now, is that they're trying to depress the right to depress the vote in the name of voter fraud, in the name of voter integrity. But all it's doing is suppressing turnout and creating more hurdles for people to jump through in order to cast their ballot, to let their voices be heard. So SB 202's criminalization elements will have a chilling effect on voters and voter engagement organizations. I mentioned this earlier. Why does this matter? This matters because we should be encouraging people to vote. We should be encouraging people to let their voices be heard. But yet the threat of criminal prosecution for various voting activities is problematic and silences the voices of the people. If people think they can get in trouble for handing out water or food to somebody in line, or for going into a ballot box to assist somebody, but it may not be the proper assistant, it may deter that person from, one, assisting, or two, the person they're trying to assist or the person they're trying to encourage from voting in the first place. And this depresses the voter turnout because some people need assistance, and because they may not have an authorized assistant, or because they want their partner or their child or somebody, their neighbor, to help them, but the neighbor is not an authorized assistant, that's an issue, because now it criminalizes that activity of unlawful assistance. And so now the person who needs the assistant may not vote, and the person who would be the assistant may think that this is just too much and decide not to vote themselves. And that's an issue. And then lastly, we've seen this chilling effect in the criminal disenfranchisement arena, as voters with felony records are scared to vote because they don't want to be seen as committing voter fraud. It's a similar issue. So I work at the Southern Coalition for Social Justice, and in 2018, we represented 5 individuals who were charged with voting while they're ineligible due to their felony convictions. And the reason why I tell this story is that we were able to get a plea deal to a misdemeanor in their case, but one of our clients at the end of his case said that he's not going to ever vote again. But not only is he never going to vote again, he's going to tell his children to never vote again. And so this chilling effect of the criminal disenfranchisement laws across the country chills voters. But this now in SB 202, this threat of criminal prosecution will have the same effect of chilling voter turnout and chilling voter assistance and chilling voter engagement, because voter engagement organizations or the people themselves do not want to get caught up in the criminal justice system for simply trying to help somebody vote, or for simply trying to encourage people to vote. They don't want that to be caught up in the criminal justice system, so they decide not to do it. And who knows, they may have a ripple effect of depressing voter turnout in the state of Georgia. And that's something that we have to fight back against, and that's why we are here today. And with that, I'll turn it over to my colleague, Mark.
Okay, thank you, Mitch, and thank you, Norm, for having me today to talk about this. I want to just echo what Mitchell just said, that, the idea that SB 202 is going to have a chilling effect and deter folks, I think there's really no question about that. When we were representing Ms. Pearson, this was even before SB 202 went into effect. We were speaking with people down in Coffee County where she was charged, and particularly Black people would tell us frequently that they were too afraid to go vote. And that was even before SB 202 came along. So I think that's a really important point to keep in mind. What I want to do for the rest of our time is talk a little bit, we're hoping that some of you who are watching are doing so in hopes of representing people who may be charged with SB 202 or related crimes related to voting. And so what I want to do is talk a little bit about some lessons we learned in representing Ms. Coley-Pearson a few years ago, and some ideas about strategy, and then go a little bit deeper into some of the criminalization aspects of SB 202 and how we might want to fight back on them in case you do get a case that involves a Georgia, alleged Georgia voting violation. So I just have this here. Again, Mitchell mentioned this, State of Georgia versus Olivia Coley-Pearson. Ms. Coley-Pearson was my client. If you want to read up on it, there's a BuzzFeed News article that's still online that tells sort of the story. Essentially, Ms. Coley-Pearson was the first ever African-American city commissioner in Douglas, Georgia. She served her community in that role for approximately 20 years. She had no prior criminal record whatsoever. She was charged with 4 felony counts for showing a first-time voter how to vote in 2012. If you remember, 2012, President Obama was on the ballot. There was a significant turnout down in Coffee County, and after that, they indicted her. She was originally tried in Coffee County, and the first trial ended in a hung jury. The vote was 11-1 to convict her of 2 counts, false swearing and improper assisting a voter. That's when we learned about the case at the Southern Center, and we took her on as a client at that point. And I want to let her, in her own words, tell a little bit about what happened next.
I received a letter in the mail from the Secretary of State's office informing me that there was an investigation going on about the 2012 presidential election, and that they were having a hearing in Macon, Georgia. They mentioned to me that I had assisted a couple of voters in the 2012 election. The next thing I heard was when I got a letter from the clerk of court in May of 2016 informing me that I had been indicted on 4 counts. 2 counts of improperly assisting a voter and 2 counts of false swearing. But at no time was a voter ever told, will you vote for so-and-so? Or never did I touch a person's screen and vote for them. I just enjoy and love serving my constituents and the citizens of Douglas, Coffee County, Georgia. The rest is history. Wayne County jurors saw through it and they did the right thing, a not guilty verdict. To God be the glory.
Okay, so as Ms. Coley-Pearson intimated, she was acquitted in that second trial. The jury deliberated for approximately 20 minutes before acquitting her of all charges. And so I want to talk about a few of the strategies we undertook that may or may not be useful in a case that you might have. Originally, we engaged in, we filed a bunch of demurs. If you're not a Georgia lawyer, that's basically a motion to dismiss the indictment for some sort of defect. And so we engaged in a fairly robust litigation regarding the indictment. And we were able to win dismissal of the unlawful assistance charge because if you take a look, there was no such crime of unlawfully assisting a voter pre-SB 202, and I'll talk about that more in a minute, but they actually had indicted her with a crime that didn't exist. And at her first trial, 11 jurors voted to convict her of a crime that didn't exist. So we were able to convince the DA actually to dismiss that charge after filing several demurs. But still a felony remained, a felony of false swearing. So we had to try that case. And so we moved for a change of venue because Ms. Coley-Pearson was fairly well known down in Coffee County. And we actually, we won that on the papers. However, the judge over our objection moved the venue to a smaller and less diverse community in a little further southeast in Wayne County. We tried the case in Jessup, Georgia. So I think that's one lesson, that a change of venue may be a motion you want to think about engaging in, especially if your case garnered media attention like ours did. However, be aware of where you might be transferred to. The next thing that happened, of course, I say, is that during jury selection, the prosecutor struck 4 out of the first 6 potential African-American jurors. The judge found no Batson violation over our objection. That's something I think you'll want to look out for. As Mitchell suggested, I think these are probably going to be racially motivated prosecutions. And so I would imagine that the prosecutors are going to want to attempt to keep Black people off the jury. So be prepared for that. Be prepared on your Batson litigation to make the Batson objection. At trial, the prosecutor called the voter, the person that Ms. Coley-Pearson allegedly improperly assisted. She was, again, a young Black woman, first-time voter, who basically came in and said, I didn't know how to use the machine. Ms. Coley-Pearson was there volunteering, and she showed me how to use the machine. And that was about it. And then the prosecution called the chairman of the County Board of Elections to talk a little bit about policy and how elections are run. And then they introduced a bunch of voter assistance forms, which are forms that a person fills out to say, I need assistance. And then the assister signs it and says, I'm doing the assisting. And Ms. Coley-Pearson's signing of that form saying, I'm assisting this voter, and I swear that I'm entitled to, essentially, is what got her charged with the false swearing. We called a couple of character witnesses, a war veteran from her community and a pastor from Ms. Coley-Pearson's community, to talk about her character for truthfulness. Again, something you might want to consider in your case if it's a false swearing case where deception is an element. And then another thing which I'm going to get to is we filed a number of specifically requested jury instructions, which we then forced the judge. He of course denied all of the requests, but I thought we made a decent record in the event of an appeal based on filing the number of jury instruction requests that we did. So that's what happened in Ms. Coley-Pearson's case. Again, I'm going to come back to some of the stuff we did and see how it might be applied if you get a case under SB 202. And that's a photo of Ms. Coley-Pearson raising her fist after the jury read its verdict. But I want to go back for a moment, because I think in order to properly understand SB 202, you need to understand what the situation, the legal landscape was pre-SB 202, because you may still come across charges under those statutes. A really important statute to be familiar with is 21-2380, which defines absentee elector. And something that was unknown to me at the time when I took the case is that typically absentee electors it's not just mailing in of a ballot. If you go to a polling place, if you go to your polling place and vote in person before the actual day of the election, that typically constitutes absentee voting. So when you see in SB 202 the repeated use of absentee ballots, that doesn't just apply to people who are mailing in their ballots. It also applies to people who go in prior to vote to the election day to vote. 21-2-385 and 21-2-409 are the two statutes the prosecution tried to cobble together to charge Ms. Coley-Pearson with unlawful assistance of the vote, because, and Mitchell hinted at this, they prevent assistance unless the voter is physically disabled or illiterate. But if you'll see under the statutes, neither one of those is criminal statutes. They don't criminalize the conduct. What it is it's administrative. It's dealt with administratively. It's dealt with via the Secretary of State, via an allegation of election misconduct. It's a civil. It's not a criminal. Those aren't criminal statutes, and that's what we were able to use to convince the DA to dismiss the improper assistance charge. And I also want to just point out the language there, which talks about a quote disability, which renders a voter unable to see or mark the ballot. Well, I think you can look at some of the legislative history around the word disability and try to determine what does that mean? Does that mean a physical disability? Does that mean a mental disability? Does that mean some other disability that impacts or prevents a voter from being able to vote? But again, none of those were criminal statutes. The criminal statute pre-SB 202 was 21-2-568, which you probably still want to be aware of because it does criminalize voting conduct, but and there are 5 subdivisions, and that's what criminalizes kind of the stuff you think of as typically, voter fraud, like intentional obstruction of people voting, intentionally coercing people to vote a certain way. Those are the sort of blatant instances of what we think of as voter fraud. So that was sort of the situation here in Georgia before SB 202, but then earlier this year, we got SB 202, and as both the National and the Georgia Association of Criminal Defense Lawyers stated in a press release that was issued yesterday, SB 202 creates new criminal offenses, nearly all of which make it a crime to engage in activity that is not only routine and commonplace, but also entirely harmless and innocuous. So I want to go through a few of those. I think I pulled out 5 of the sanctions that I think you might come across, so that we can talk a little bit about how you might handle it. And I've noted where those provisions can be found by line. The SB 202 is a long bill. It's available publicly on the Georgia legislation or Georgia State Legislature's homepage. And if you pull up the current version, you can find these provisions if you go down to the line I've indicated. So line 974, this provision, and Mitch has hinted at these. I just want to dig a little bit deeper into the actual language. What this one says essentially is that no person other than the elector or someone authorized to request an absentee ballot for the elector shall handle or return an elector's completed absentee ballot application. So we're not even talking about a ballot here. We're talking about someone who is requesting an application for an absentee ballot, right? If you think about it, if you ever voted early, right? If you ever go in person, you sign a little form before you actually get your ballot. That is an application for an absentee ballot. Or if you do it from home, you get something mailed to you, you fill out an application, you send it in, and you get your ballot. This provision criminalizes handling an applicant's or an elector's completed absentee ballot application. So a couple of notes, it strikes me as overbroad, and you'll notice there's no mens rea, right? And so I think those are 2 arguments that can be brought in a demurrer or a motion to dismiss if you get a charge under this provision. You can argue that you can argue what the mens rea should be, argue that they haven't alleged it properly, and you can also argue that it's overbroad such that it should be dismissed. And there is law that's supporting this. We went through a lot of it in our demurs. We made these arguments even as to the false swearing charge. So the law is out there. I haven't provided it all here, but I'll provide some in a moment. So the next provision I want to talk is at line 1347. And this is the one that talks about false swearing, right? So when you fill out an absentee ballot, you actually have to swear an oath that you have marked and sealed the ballot in private and not allowed any unauthorized person to observe the voting of the ballot, and that you will not give or transfer the ballot to any person not authorized by law. So I've italicized these words authorized, unauthorized, not authorized, because I think that's one of the problems in this statute, right? It turns on your interpretation of authorized, of who is authorized, and it turns on the voter's knowledge of that definition, right? So if a voter, like in Ms. Coley-Pearson's case, goes into the polling location to early vote and sees a volunteer and says, "Excuse me, ma'am, I don't know how to use this machine. Can you show me?" And the person shows her. Nobody has any criminal intent. Nobody even knows that that's maybe not an authorized action. But yet, once that ballot gets signed, once that oath gets signed, the voter and possibly the assister are potentially subject to this criminal sanction. So again, I think that's overly broad. I think you can make arguments about whether or not they've proven or that they've demonstrated in a demur, in an indictment or in a demur, that that the person is or is not acting in an authorized way. And another good case in Georgia that I want to direct you to is the Spillers case. It's an appellate court case from 2009. The site's there. And it's a good case because it talks about how false swearing requires an intent to deceive. So it's not just the act of swearing itself, the act of signing a false document. You actually have to intend to deceive. And that was the bulk of my closing argument in Ms. Coley-Pearson's case, that they had not proven any intent to deceive. I believe the judge instructed on the requirement of intent to deceive. And so that was, I think, a large reason why we were successful, because we were able to convince the jury that there was simply no evidence that Ms. Coley-Pearson was trying to deceive anyone in showing the first-time voter how to vote. So next provision I want to mention is at line 1873. And this is the line warming, so-called line warming provision, that no person shall give any food or drink to any elector. A lot of problems with this law, I think. This may be a provision that results in mass arrests. I don't know, but you may come across this charge. Again, there's no mens rea here. I think you can do a lot with that in a demurrer or even at trial, arguing about what the mens rea should be, if it's strict liability, whether that's constitutional or not. It strikes me that there's an overbreadth argument here. You can think of scenarios if somebody is passing out, are you allowed to give someone food and drink? I don't know, under the letter of the law, I guess not. There's a First Amendment right to free speech, a right to associate, and I think these can all be worked into your demurrer. And I think why it's important to understand the background that Mitchell gave at the beginning is that you can work that narrative into your motions practice. You can work that into your litigation strategy and really create this narrative of this is just sort of another example of new Jim Crow. And that flows into the next argument, an equal protection challenge based on discriminatory intent, discriminatory enforcement, and application. I'm going to talk in a moment about ways you might be able to investigate that claim and sort of prove that up. And then really anything else you can think of. This is these are bad laws, and so I think it's important to be creative and to argue even new, creative ways against it. Next provision, line 2449, So again, this makes reference to some of those pre-SB 202 laws, which is why it's important to know them. So this provision says that except while providing authorized assistance in voting under 212409. Now recall 222409 is the provision that talks about not allowing voting assistance unless the person is physically disabled or illiterate, right? So except while provide, and again, those terms aren't necessarily defined. What is physically disabled? What is illiterate? Mitchell said, what if you don't read English, right? If you read Spanish, are you illiterate in the English language? There's some problems with those definitions or the lack of definitions. But anyway, except while providing authorized assistance under 212409, no person shall intentionally observe an elector while casting a ballot. Again, I think here, this turns on the interpretation of authorized. Who is authorized to do that? And is the voter, does the voter know of that authorization? And then finally, the last provision I want to mention more in depth is at line 2442, where this criminalizes knowingly accepting an absentee ballot from an elector for delivery, except as authorized by 212385, which is a pre-SB 202 law that allows family or household members to do so. So again, like Mitch said, a neighbor can't take your absentee ballot from your home to your mailbox for you, right? And so I think, although there is a mens rea in this one, if you notice, most of the SB 202 criminalization provisions do not have a mens rea. This one does, it's knowingly, but I think there's definitely an argument of overbreadth because it applies to well-meaning non-family volunteers who are simply helping to get the vote out. So before you engage in your motion strategy and your pretrial litigation in these cases, a couple of thoughts on investigation that were fruitful in our past cases. One thing you can do is you can request documents via an ORA, Open Records Act request, from the Secretary of State regarding your county and your election and your client and the accusers. Because what usually, I mentioned this, pre-SB 202, these cases weren't handled criminally. They were handled by the Secretary of State. And so what the County Elections Board will do is they will make a complaint to the Secretary of State alleging some sort of impropriety. That then is reviewed by the State Elections Board. There are hearings every so often in which all the cases are reviewed. Sometimes evidence is presented. And so you may actually be able to get information from the Secretary of State about your county's Board of Election, particular elections and how they ran, and about your client and the accusers, if they are employees of the County Board of Election in particular. So I think that's an important investigation step to take. In Ms. Pearson's case, for example, the Secretary of State, which at the time was run by now Governor Kemp, actually dismissed the complaint that was made against Ms. Pearson. So the Secretary of State dismissed the complaint against Ms. Pearson, and then they tried her criminally. But they upheld a complaint against the County Board of Elections, who are the people who were accusing Ms. Pearson of impropriety. So we were able to learn all of that and work that into our narrative of the case, because we were able to get those documents from the Secretary of State demonstrating that. Second, I think important idea to think about is to send an ORA to the GBI, the Georgia Bureau of Investigations, requesting the names of people arrested, charged, and or convicted under the crime with which your client is charged. And you can ask for racial demographics, year of arrest, county, and I think this can possibly help build a claim, an equal protection claim. What we might see is that that enforcement, particularly of certain provisions like the line warming bill, might be discriminatory, right? In our case, this was useful because we actually requested the names of every person ever charged with those, what we thought were made up crimes of unlawful assistance. And the GBI confirmed repeatedly that no person in the state of Georgia, pursuant to their records, had ever been charged with the crime Ms. Pearson was being charged with. So again, that was helpful to know in our pretrial litigation. So those are a couple of things you can do early on if you do get one of these cases to start your investigation going. So I want to now turn to the motions, which I've been hinting at or mentioning a few times. We did a pretty robust motions practice in Ms. Coley-Pearson's case, and I would encourage it in SB 202 cases. And if nothing else, even if you lose, it's important because you're setting a narrative and you're creating a record on a law that's brand new, right? So if imagine you have a case involving unlawful voting or unlawful assistance under the new provisions, right? The 4 or 5 new provisions that I just went through. I think your demurrer can make several different arguments, right? One after the other. There's either that there's no mens rea alleged, and that's unconstitutional, or it's insufficiently alleged, and that's a violation of the law. I think you can be creative there depending on which charge is being levied against your client. Remind the court that the rule of lenity applies in reading the indictment in criminal cases, right? You're supposed to read criminal statutes in the light most favorable to the client. That's under the rule of lenity. I've mentioned unconstitutional overbreadth a few times. You can also raise a claim of unconstitutional vagueness, which encourages discriminatory enforcement, right? The law might be too vague. Several First Amendment claims, you can look to some of the civil litigation that Mitchell mentioned to use some of the law that they are citing. I think if you can argue that on a demurrer that the prosecution can't be constitutionally continued because it's a constitutional violation, it violates the First Amendment. And there's another interesting one, which I think is important to throw in there, which is preemption, right? The idea, there are a few types of preemption, but generally the idea is that if Congress has legislated or has demonstrated an intent to legislate in a given area of the law, states are preempted from legislating in contradiction to that. So the idea would be that Congress has demonstrated via its legislation that it intends to protect a person's right to vote. And so Georgia is prohibited by federal preemption from, prohibiting or obstructing the right to vote in the ways that it has tried in SB 202. So there are more arguments you can make. I'm sure, again, I encourage creativity, but those are a few that might be able to get you started. What if you have a case of false swearing? Because I do think those will probably continue to be around. I go back to the no intent to deceive. In our case, I don't think we argued at the demurrer stage that she didn't have an intent to deceive because that was going to be our trial theory. And we kind of wanted to hold that close to the vest and come out with it at the trial as opposed to in the pretrial motions. But be aware of that pretty good case out there of spillers if you have a false swearing case. And then does the oath actually prohibit what was actually done, right? In Ms. Pearson's case, she said that she signed a form that said she was going to assist a voter. Well, did she really assist the voter? She didn't mark the ballot. She didn't touch the screen. She didn't really do anything. And so you can maybe make an argument that the oath actually wasn't violated. A couple of other motions, just before we finish up, that I think you should keep in mind. Motion, again, this could be separate from the demurrer, a motion to dismiss on equal protection, due process, vindictive prosecution grounds. Again, if you get that information from the GBI, that could help support that claim. Also, I think what you'll probably see is a lot of the times the clients who are getting arrested for this are people who are civil rights activists or are known in the community, right? Ms. Coley-Pearson was a long-time commissioner, a civil rights activist. She was known in the community. There were people who did not like her. And so that, I think, may have played a role in her prosecution. And so you might think about whether you have grounds for a dismissal. A change of venue, which I've mentioned, just be aware that, careful what you ask for. You don't know where you're going to get moved to. Another thing in Georgia law, if you're not a Georgia attorney, if you lose, you can, under OCGA 5634B, you can request that the trial judge certify the question for immediate review. And this might be an interesting thing to try, especially if a trial judge is looking to avoid trying the case, but doesn't want to be the one to sort of strike down the statute, right? You can file your motion to dismiss, maybe you make your constitutional argument. The judge denies it, and then you request that the judge certify the issue to the Georgia Supreme Court for immediate review. If the judge does that, then the Georgia Supreme Court has the option of hearing the issue pre-trial. And it might be, these might be issues, I don't know, that the Georgia Supreme Court might have some interest in. They will all be issues of first impression applying these statutes. So that's something to keep in mind, given, if it makes sense for the circumstances of your case. Again, specific jury charges, I mentioned this before. I think you want to try to throw out as many requested specific jury charges, particularly ones that define the terms that turn your case, right? The mens rea, the intent to deceive, the authorization, who is authorized, what constitutes assistance, right? What constitutes a disability? I think those are important instructions to ask for, because maybe you'll get them, and if not, you've made a record. And then the other thing we did in Ms. Pearson's case, which I thought would have been helpful, was file a proposed juror questionnaire. Because this is unlike maybe the run-of-the-mill criminal case. These are cases that have raise a lot of political questions, right? And a lot of political feelings, particularly in these days. So it might be, we didn't win this, the judge didn't allow the questionnaire, but a questionnaire that gets at some of the jurors' possible political leanings might be useful. So it's something to consider. So in the end, I want to mention one other law that I think you might see used to try to further suppress the vote under SB 202, and that's a charge of trespassing. I currently represent a client who was charged with trespassing for driving voters to the polls after told not to. I think that people may be attempting to give water to voters, maybe people attempting to drive voters to the polls, maybe people trying to assist someone who needs help walking into the polling place. There may be a charge of trespassing that you'll see. Few quick notes on that. The trespassing statute, and this is supported by a lot of federal law, I believe, requires that the person be given a reasonable time to leave before being charged with trespassing. If it's the county board who's kicking them out or charging them with trespassing, does the county sheriff, who's acting on their behalf? Are the city police acting on their behalf? Or is the county sheriff acting on their behalf? There may be, again, questions with authorization to act. And I think you also can add a federal preemption issue here. Congress wants to ensure people have the right to vote, and treating people assisting with that right as trespassers should be preempted by federal law. And in the end, though, I think the most important takeaway is, the strategy must be one that's local. It must be focused in on where you're going to be trying the case, right? I live in Atlanta. I spent a lot of time in New York and DC. I tried Ms. Coley Pearson's case in Coffee County and then in Wayne County, which is where we went the venue to. So I had to talk, we associated a local criminal defense lawyer from Jessup, Georgia, who was incredibly helpful. She sat with us during jury selection because she knew the community, right? I'd strongly encourage, if you have a case that's not in your jurisdiction, if you're volunteering to take a case in some other jurisdiction, talk to the local attorneys, learn about the community, read the newspaper, see what suggestions the local lawyers have for how best to convince your judge or your jury that this should not be a crime, or that the verdict should not be guilty. And with that, I want to say thank you to Norm and Mitchell again, and thank you to everyone for watching. I hope that was helpful, and good luck.